Frequently
Hi
asked
guys, Alena
asylum
Shautsova,
questions.
immigration attorney from New York is here. In this video, I will answer 3 most commonly asked questions about asylum in the United States. Number 1, can you withdraw your asylum case if you found a different way to get status in the United States? For example, you are marrying U.S. citizen and you can adjust your status. You have a TPS pending or a U visa pending. Well, yes, you can. This is your right to withdraw your asylum case. Of course, the matters may be complicated if you are already transferred to court, so you will have to work with your attorney as to how to apply for relief in court if you're subject to removal proceedings. But generally speaking, yes, you can withdraw your case. The only thing is this: I usually do not recommend withdrawing the case until you have your other status secured. In other words, before you receive that actual TPS, temporary protected status, or U visa, or before you receive that green card based on adjustment of status, I wouldn't recommend withdrawing your asylum case. Number 2, I'm always asked this question: is it possible to speed up my asylum case? Well, in theory, it is possible, and the only way it will be done is such. You would have to request to expedite your interview if we are talking about asylum pending before USCIS. If you are in immigration court, in theory, it's also possible. You will have to request that the court advance your hearing date, okay? So it's possible, I say in theory, just because requests to expedite one's interview subject to a very high standard, you have to show that you have a very good reason for that, and it's hard to have those requests granted. And finally, if you filed your asylum case while you were still in status and now you found an employer who is willing to sponsor you and you are still waiting for your asylum interview, can you adjust your status? Well, the answer is probably yes, because there are 2 cases that indicate that you should be able to, but it will not be easy, maybe, because you will have to show that you are subject to an exception to maintaining your lawful non-immigrant status. This requirement is a must when you are filing for adjustment of status based on an employer's petition. So there may be a battle ahead, but it should be possible. Thank you very much for watching. Stay on top of your immigration case.